Welcome to Justice for New York. I'm your host, Charles Collins. All documentation concerning Justice for New York videos can be found at justicefornewyork.com. About 2 years after I wrote that letter and the charges were dismissed, I still wasn't getting anywhere. I'm still being hammered in the family court system, still being deprived of my constitutional rights. I thought I'd up it a little bit. Man charged with setting off a smoke bomb. All it does was generate smoke. Nothing else. I even admitted to doing it. Troy Man admits smoke bombing. Right here, 2 cleaners discovered 3 smoke bombs, 2 of them already detonated in area P3 north of the parking garage on Monday evening. Peters said Capitol Police had gotten a call earlier that day about a smell of smoke in the area. This was on October 26, 95. I'm charged with it. Now the first thing they do, as they stated here, this was later on, when we 2 years ago, it took 2 years in court. He set off a smoke bomb in the Empire State Plaza with the express aim of getting himself arrested. That's right. It worked. Collins got charged initially with criminal anarchy, a felony later reduced to a misdemeanor or nuisance charge. But with prosecutors worried about murderers and rapists, a smoke bombing case with no injuries or damage wasn't real high on the list of priorities, Baines said. This guy shows up late on the day they're supposed to dismiss. He overslept. Criminal anarchy. Just to give you a little head up here. Oh, I should also mention I did a videotape for the smoke bombing, the reasons and everything else, which was given to the police. It's also, again, on my website. The smoke device. The case will show how the Albany District Attorney's Office files knowingly false charges against defendants. I will show how the court can deprive litigants of their rights, how the Albany County Public Defender's Office is corrupt in representing defendants charged with a crime. Based upon the facts here, you will see that the Albany County Public Defender's Office is actually an arm of the District Attorney's Office, helping them to get convictions. My so-called public defenders refused to discuss my case with me, misrepresented to me and lied about the law, and refused to file any papers on my behalf. Now, you also see how the Albany County Public Defenders argued in court to have charges dismissed, as they knew the charges were bogus and they knew I would win the case. Greenberg and his assistants couldn't afford to look like the fools they are. They're incompetent. They're corrupt. Greenberg, because you commit an act does not mean you committed a crime and/or a crime you were charged with. I set off the smoke bombs. I don't deny that. Criminal anarchy. With the knowledge its contents be published, sells, or distributes any document which advocates such violent overthrow. With knowledge of its purpose, he becomes a member of an organization that advocates such violent overthrow. I have never advocated or ever stated anything the violent overthrow of any government, not even the New York State government. I have advocated about the corruption in it and that it needs to be investigated, it needs to be exposed, but I've never advocated any violent overthrow, and they know damn well I didn't. What they did is they overcharged. That way bail could be set at $10,000 by charging me with a felony that they know I didn't commit. Criminal nuisance is by conduct either lawful or unlawful are unreasonable under all circumstances, he knowingly or recklessly creates or maintains a condition which endangers the safety or health of a considerable number of people. He knowingly conducts or maintains any premises, place, or resort where people gather for purpose of engaging in unlawful conduct. Criminal nuisance as a Class B misdemeanor. So they reduced it from an E felony down to they were going to try me under the criminal nuisance statute. Only one problem. As it's stated here in the newspaper, 2 cleaners discovered 3 smoke bombs, 2 of them already detonated in area P3 in the evening. This is about 5 hours later. In order to prove criminal nuisance, it is essential to prove injury as an accomplished fact. Well, if nobody knew they were set off, which is admitted to in the article, and again, this is all on my website, where was the injury? None of the alleged in the complaint. The newspaper articles the next day stated there was no damage done, and it wasn't discovered until cleanup that night. So where was the considerate number of people that were injured? There weren't any. This is why it is very important for your attorney to do discovery. If they do not do discovery, they are incompetent. That's what I had, and I'm going to get into that. On March 2nd, over a year and 4 months later, the following article was in the Times-Union. As the charges were dismissed on February 27th night, defendant insists on his day in court. Prosecutor wants to dismiss charges, but a Brunswick man is willing to risk jail. They couldn't prove their case. That's how stupid the Albany County DA's office is and how corrupt it is. No, they're not going to investigate the corruption across, up the street a little bit at the Justice Department and these judges issuing orders that violate the law or anything. Oh no, that's too much work. And that they were worried about murders and rapists. A smoke bombing case with no injuries or damage wasn't real high on their list. Wasn't real high once they knew I was entitled to a jury trial, and they couldn't prove their case. If it was before just a judge, they could. Baines says obviously denied the conspiracy allegation. What Collins really wants is a forum to debate the family court law in New York State. Baines said he wants to subpoena Chief Judge Judith Kaye and other luminaries. Right, that's why I did it. They were forced me to do it. Because these stupid people, including Baines, knows exactly what's going on, but they don't give a damn about people's constitutional and civil rights. The court held that the prosecution could not rely on the judge sitting the matter for trial as a substitute. It is interesting that this argument was never forthcoming until I discovered the newspaper articles. Now, what happened was, I went into court. Well, this is going to be the history of the case, but knew the false charges were false. The prosecutor's different any factual allegation to support 2 elements of the criminal nuisance in the second degree. 1, the defendant's conduct endangered the safety and health of a considerable number of people. They knew that. Now, don't tell me these prosecutors don't know the law, but they thought they were going to nail me and send me to jail, that the judge was going to hear the case. No allegation was made as to how anybody's safety or health was endangered. Well, they couldn't because nobody's was. For information, alleged facts to support the element, a considerable number were jeopardized. Nobody was jeopardized. Accusative instrument which fails to allege necessary elements stands jurisdictionally defective and must be dismissed. Oh yeah, I even put in here, he had overslept. He was having nightmares the night before that the matter might go to trial. It wasn't going to go to trial, but, he couldn't make it in court. And I'll tell you, I've never seen a judge, somebody came in with a traffic ticket. They moved me to another area where they handle traffic tickets in City Hall, where nobody was. Some woman walked in. Everybody was in shock. Here, you got an adjournment, and out the door they sent her. They didn't want anybody around. History of the case. On October 25th, bail was set at 2 charges. Criminal nuisance, criminal anarchy and criminal nuisance. I was charged with the criminal nuisance at the time. They just never took the criminal anarchy to the grand jury because they know there was no proof or any documentation that I've ever promoted the overthrowing of any violent overthrow of any government. And it says violent overthrow. I haven't even advertised the overthrow. All I've stated is these judges need to be held accountable. I appeared before a city court judge and was informed by the public defender, George Mem, and that the district attorney's office would probably not pursue the criminal anarchy charge and that it would be dismissed. When I asked Mr. Mem if I was entitled to a jury trial on the criminal nuisance charge, he informed me that I was. On the 27th, I had to go back. I was informed by the public defender's office this case had been transferred back to Albany Police Court and that the district attorney had set the case down for a conference at NAM Tuesday, December 5th, at which time I was to appear in court. On the 5th, I was informed by my so-called public defender, Trish DeAngelis, that the district attorney's office had not completed the paperwork and therefore I would not have to appear. Stated that it was her understanding that I did not wish to plea bargain. That was absolutely right. Why would I plea bargain? I didn't do anything wrong. I asked Ms. DeAngelis if I was entitled to a jury trial on the criminal nuisance charge, and she stated yes. She told me to come back on Tuesday the 12th. On the 12th, I appeared, and I met with Ms. DeAngelis for about 2 minutes just before going before Judge Stephen Herrick. And we're going to deal with him a little bit later on, but she again asked about plea bargain. I repeated I had no intention to plea bargain. Again, I asked her if I was entitled to a jury trial. Now she's 80% sure. She doesn't know the law. Either I am or I'm not. I was entitled to a jury. You would think Ms. DeAngelis would look it up, or even better, that she should know the answer since she handles hundreds of cases and was in court on a daily basis, supposedly representing defendants in criminal matters, and most of them are A and B misdemeanors. I was then taken before Herrick. I tried to inform DeAngelis that I had already been arraigned on the criminal. She didn't even know what charges I had been arraigned on the first time in court. I was charged with 2 things. Then, about 5 minutes later, the court found out that there was only one criminal nuisance charge against me. Obviously, Ms. DeAngelis did not know what I had previously been arraigned on, and certainly did not want to hear from me. I didn't know what I was talking about when I told her that. Judge Herrick stated, I am setting this down for a non-jury trial for January 4th. Non-jury trial on the 4th. That means the DA's office has stated they're ready to go to trial. Mr. Mem and Ms. DeAngelis just stood there like bumps on a log. They did not say anything. I then spoke up, which my public defenders should have, but they didn't. But this is how the Albany public defenders represent people. I spoke up and said that both the public defenders had told me I was entitled to a jury trial, at which time the court took a break to check the law. Wouldn't you think the judge and the attorneys would know whether or not I'm entitled to a jury trial or not? After I spoke up, Mr. Mem said to me I had asked about a Class A misdemeanor. Why would I ask about a Class A misdemeanor when I'm charged with a Class B misdemeanor? And in a minute you will see how this statement is like Hillary Clinton. What difference does it make if I was charged with a Class A or Class B misdemeanor? I asked if I was entitled to a jury trial on the criminal nuisance. Knew it. Why would I ask if I was entitled to that? When the court came back, I was informed by Judge Herrick that I was not entitled to a jury trial. Ms. DeAngelis then informed me that I faced only 90 days of imprisonment and wasn't entitled to a jury trial. That was a bunch of crap. I faced up to 6 months in jail. Obviously, she doesn't even know what what the penalty is. And she's representing these people? And the judge doesn't know? As he stated, I'm not entitled to a jury trial? Now we'll see how stupid that is in a minute. Ms. DeAngelis then handed me a card with a trial date on one side and her name on the other. She told me she would see me on January 4th at 1 p.m. Well, that's the time of the trial. Obviously, she had no intention of discussing my case prior to going to trial on January 4th at 1 p.m. How did she plan on representing me? The Albany County Public Defender's Office had not even made any discovery demand. Who were they representing, or more importantly, who were they covering up for? The DA's office. When you go in, you make sure your public defender does discovery. If they don't, they're incompetent. The only reason I found out about this stuff was of my complaining. The next day I received a letter from Judge Herrick dated 12th. His letter stated, upon further review of the issues discussed at your appearance in court on December 12th, it appears that the criminal procedure law does entitle you to a statutory right to a trial by jury. I am therefore adding this case to the jury term scheduled for February 96. You will hear from your attorney. Here is the letter. Modes of trial. This is how simple it is. 340 of the criminal procedure law. In any local criminal court, a defendant has been entered a plea of not guilty to an information which charges a misdemeanor. Doesn't say A or B, it says misdemeanor. Must be accorded a jury trial. Conducted pursuant to Article 360, except that in New York City criminal court, the trial court of an information which charges a misdemeanor for which the authorized term of imprisonment is not more than 6 months must be a single judge. So in other words, a B in New York City, you're not entitled to a jury trial. But in the rest of the state, you are entitled to a jury trial. To me, that's a denial of due process and equal protection law. It depends on where you live, what rights you have. So here he is. You got Judge Herrick, who's been on the bench several years at this point. Trish DeAngelis, who became Rensselaer County DA. How, I'll never know. George Mem, who is as useless as they come. So's DeAngelis. And you got the assistant DA. You got 4 people that don't know the law that a person charged with a misdemeanor, whether it's A or B, because it says misdemeanor, is entitled to a jury trial. How many people in Albany County have been stripped of their statutory right to a jury trial in upstate New York or out on Long Island? Because the judges don't know that if you're charged with a misdemeanor, you're entitled to a jury trial. This is how they're screwing people over and over again in Albany County. They tell you you're not entitled to it, it's easier to get you to plead. Or you go before the judge where the case is already fixed against you. Because the judge and the public defenders are there to protect the judge. I just read that. Obviously, my so-called public took no action to protect my statutory right. And in fact, they didn't even know about it. And I'll tell you something else about Miss DeAngelis. The only worst, in my opinion, she was one of the worst DAs in Albany and Rensselaer County. Only to be surpassed by Richard McNally, who refused to prosecute. My next-door neighbors were stopped at a school bus in Wyanskill. A drunk driver comes around the corner from behind the bus just as the 8 kids were crossing the street and just got to the other side and hit them head on in their SUV. Thank goodness it was an older SUV that was thoroughly made. If they'd been a small car, they would have been dead. They were told by his office that they were not going to prosecute the drunk driver because it wouldn't do any good. Have you ever heard of any such thing? It makes you wonder at times, doesn't it? He's lucky he didn't. What would they have done if he had killed those children crossing the street? You know, Mr. Mem is setting up a trial date and has never discussed my case with me. On Tuesday the 23rd, Mr. Mem called my house and talked with my mother. He told her that he was meeting with Judge Herrick to set a trial date on Wednesday, January 24th. He wanted to know if I had any witnesses, as they needed 10 days' notice. He was not asking to set up an appointment to discuss my case. He didn't even want to hear from me. How do they prepare you when they're going to meet with you 5 minutes beforehand? Is now setting up a trial date, has never discussed my case, has done no discovery. When Mr. Mem planned on meeting with me to discuss my case, was it his plan to discuss it over the phone or just before going into the court in the hallway, as was Ms. DeAngela's plan? Is this how the Public Defender's Office represents defendants? No wonder they lose most of their cases. They're not prepared. They're depriving litigants of competent assistance of counsel. I was never informed of any conference date as stated in Judge Herrick's letter of December 12th. On Wednesday the 24th, I phoned the Public Defender's Office to speak with me. I was informed that he worked only on Mondays and Tuesdays and that there was no way I could reach him. His secretary at the Public Defender's Office refused to take a message from me. How nice that is. How does one get a hold of his public defender? When I told her I was returning his call and that he wanted to know if I had any witness, she attempted to reach him at another number. She then claimed he was not there. She wanted me to leave the message, witness names with her. I refused. I was not going to leave my witness list with a secretary without discussing my case with my court-appointed attorney. Mr. Mem called back that morning after I left the house. My mother informed me he could not call me after that evening or following morning when I could be home. He never returned my call, and I have no way of getting a hold of him. Motion to relieve public defenders. I then filed a motion with the court to have them because they're incompetent. They don't know the law. They refuse to discuss my case with me, requesting a date to discuss my case, including why they refuse to file any motions on my behalf. I also request that they tell me how they intended to defend me. I'm entitled to this information. So is every other defendant, but they're not going to tell you. By letter, Mr. Fritz. Well, Mem, when I wrote it to him, he says you have to contact Mr. Fritz, head of the department. Fritz says, this will acknowledge receipt of your recent correspondence relative to your matter concurrently pending in Albany Police Court. I find your allegations against Mr. Mem and this office completely without foundation in fact or reason. Your decision to proceed pro se is, in my opinion, ill-advised, but nevertheless one which is your right to make and totally within your control. These people haven't done anything with me. They haven't discussed my case, and I can't rely on them. That said, please be advised, I have directed one of my assistants to bring a motion seeking permission to be relieved as your representative. I already filed one with the court. I stated, your refusal to discuss my case and allegations against your office and Ms. Mem supports my position that you are fully aware that your office is incompetent and it is no more than a tool of the district attorney's office in conspiring to deprive me and other litigants of our constitutional and civil right as well as our statutory right. Further, your statement, your decision to proceed pro se, in my opinion, is ill-advised. Wrong. I requested that I proceed pro se with the assistance of competent counsel, but that I was going to be the one to make the final decisions, the opening and closing statements, and question the witness. I have not and do not intend to waive my right to competent assistance of counsel to help me with my case. How you can state my decision to reprimand as ill-advised considering the fact that your office failed to even perform two of its most basic functions, which was to file for discovery in this case and to discuss the case with me. I know you do not want to discuss the incompetence of your office. It took them a month to file it. After waiting a month, I sent another letter. Still hadn't filed. Contained, it is submitted that based upon the aforesaid and this office is unable to work with and communicate with the defendant and as such unable to represent him. I'm not refusing to communicate with them. I'm not refusing to do anything. I'm asking them to, and they're the ones that are refusing. It was the public defender's office. I also argued, which Judge Herrick refused to grant me, I even argued that I was entitled to appointment of counsel for the motion pursuant to case law. The federal held that a defendant was entitled to be represented by counsel at a hearing on motion which he sought appointment of new counsel because of alleged incompetency of his present counsel. I was not granted counsel concerning Mr. Mem's motion, but yet I'm entitled to it. I then got Paul Edwards as an attorney. He's the one that did all the discovery demands. And that's when they decided we can't prove our case, so we're going to have it dismissed. Then it's in the, so this is how the Albany County Public Defender's Office operates. Now, guess who's going to be the new head of the Albany County Public Defender's Office? That's right. Judge Herrick is retired from the bench, and they're now going to have him as the new head of the Public Defender's Office. Wait till you see what he does in other criminal cases. He does not inform people of their rights or anything else. He covers up, just like he did here. And if he doesn't know what the rights are, which he's admitted in his letter, he doesn't know you're entitled to a jury trial, how's he going to defend all these people in the public defender's office? He going to raise this issue? I'll guarantee you he's not. And neither are any of his subordinates. Well, Sol Greenberg, strike two. You lost with the aggravated harassment charge when I wrote a letter demanding that my constitutional rights to be enforced, and you were too much of a coward to stand up and protect my constitutional rights. And now I let off a smoke bomb, and you're too busy with other types of cases. You knew damn well you couldn't prove your charges. The criminal anarchy charge was a bogus one. The criminal nuisance charge was bogus. You know both of them were bogus. You're a lying Democrat. You refuse to protect people's rights. You can't win a case, and you're supposed to be a big Democrat district attorney in this state? You're nothing but a two-bit lying, sniveling little coward who refuses to protect people's constitutional rights and to protect people in this state from corruption. You are the corruption.